So yeah, my name is Kurt Opsahl. I am the Associate General Counsel for Cybersecurity and Civil Liberties Policy with the Filecoin Foundation. I'm also a Special Counsel with the Electronic Frontier Foundation. Previous to Filecoin, I spent many years with EFF working on protecting our privacy and civil liberties. So I wanted to talk to you a little bit about that here today. And we'll start with, there we go, what's at stake? So the goal of the policy work that I do, and what we all should be doing, is help create the policy space in which the civil liberties, the future that we want to create, can thrive. And there's a number of facets to this. One, very important to this is privacy, which there's many ways of defining that. I like it as the right to be left alone, without an authority looking over your shoulder. This is trying to capture things like autonomy and control, the it's none of your business aspect of privacy. Anonymity, this is certainly strongly related to privacy, but it also brings in notions of freedom of expression, that anonymity gives you the ability to speak, to associate, to interact in a society without the forced exposure of your identity, which could lead to retaliation if people don't appreciate your views or are intolerant of them, and allows greater access to the marketplace of ideas. It also encompasses the right to read anonymously, to receive the information that helps you understand what your political and social views are, and be able to do that without someone looking over your shoulder. And these all come down to free expression. This is, again, the marketplace of these, being able to advocate for your social and political views, and keeping away from a government censoring the views that they don't like, that they don't want to compete in the marketplace of ideas. And then I'm adding on to here a very important thing, innovation. This is something that is necessary to create this brighter, decentralized future that we're struggling for. And these fundamental rights, privacy, anonymity, free expression, need to be intact both to create that future and have it thrive, but also for it to be made in the first place. So policy doesn't act alone. It is part of it. I look at it at three different things. Policy sets the space, tries to set up what norms are and goals, ideals, and if these are believed in by a large portion of the population, if people are in agreement on what the policy should be, this is like explaining why do we have these rights, why do we seek to have them, what are they good for? Then you have law, and this is a way of setting the rules, writing down this is the rules for a society, how to enforce them, and I have like constitutions, statutes, legal process, and then the third pillar of our tripod, technology. This provides an additional layer of protection. So the thing is that policies can be ignored, that laws and rules can be broken, and so you can have technology which has, especially if it's open source, people can look at it, can look at the math and logic and use that instead of having to just trust me as an alternative. So it helps shape these things. So with these shaping the laws and the norms makes it harder to gain support for violating the principles of law or breaking into technologies. It at least makes it something that someone has to hide or pretend that they're not doing. So it provides that layer of protection by setting it so it goes against the society's desires and goals to break these rules or to break these technologies. Then the laws, they can codify these policies and provide a process. So I use the example here of the exclusionary rule. This comes from the United States, and if evidence is gained in violation of the Constitution, it can be excluded from the trial. So somebody who factually may be guilty, nevertheless, is allowed to be acquitted because that evidence is excluded, and you say, well, that allows somebody onto the street. But it's a good thing for society to have that, because if you don't have an exclusionary rule, if you don't have any consequences for some violating the Constitution and allow them to get their job done while violating the Constitution, then they can do it all the time without consequences, and then the law becomes not very useful. The constitutional protections become not very useful. And then finally, getting back to technology, things like end-to-end encryption, multi-signature authentication processes, peer-to-peer networks, these kinds of technologies can make it more difficult for someone to violate a policy, break a law. If you have end-to-end encryption, they have to break the encryption or break into the endpoint to find out what the communications are. With multi-sig authentication, you can have some regulatory arbitrage. You can have people in different jurisdictions, all of whom are required to sign something, making it more challenging for someone to violate these principles and get at the information without going through the due process of law that would be acceptable to all of those jurisdictions. Peer-to-peer networks move things away from a centralized point of failure. A large company that is a centralized point can be a target for governments or bad actors of all stripes to find one place where all the information is, or the connecting point, taking that over and making it more difficult to have your civil liberties. So we're going to talk about some of the threats to around the world, and we're going to take a deep dive into one threat. I wanted to call this out because this is an international audience. This is an international treaty, a treaty on cybercrime. It's currently negotiated through the United Nations. And why should we care? Well, because the desire to detect and prevent crime is often the reason given for threats to civil liberties. We need to have this, people say, because of the crime problem, and we can't tolerate this, so we have to sacrifice certain rights. And I think that this leads to over-criminalization, where they feel like, we'll make the penalty so harsh that no one will dare do this, but then you get some draconian penalties. Expanded surveillance and investigative authorities say, well, we need to capture this information to get the bad guy, and so we all need to sacrifice some of our privacy. And a lot of this is based on the notion that it's a trade-off, security versus privacy. But that's a false dichotomy. In fact, security needs privacy to be effective, and privacy needs security to be effective. So the UN Cybercrime Convention, this is an idea to create one treaty to rule them all. It is a proposed replacement for the Budapest Convention. We'll get to that in just a second. But it started with a General Assembly saying, yes, we want to go forward and host these negotiations. The UN created the Ad Hoc Committee, which is a very generic name, but that's how they roll. It is out of the Office of Drugs and Crime, which can give you a sense of that it's coming from a law enforcement point of view, right? It's not coming from the Office of Human Rights. It is coming from the Office of Drugs and Crime. And it's been going on for several years now, so since 2020, so 4 years. And originally they planned 6 sessions to negotiate it. 4 and 5 already happened this year. They were in Vienna in January and April. There's one coming up in New York City, the head office of the United Nations, that was supposed to be the last one in September, but it's been a challenging process, and they have added another session for early 2024. And this is actually a good thing because it gives more time to make sure that this is a treaty that respects human rights, respects fundamental rights. So today it was designed to replace the Budapest Convention. The Budapest Convention came about from the Council of Europe, and has been signed. In red there, you can see various signatories to it. So signed by a number of countries around the world, but you'll notice it's certainly not all of them. And you'll also notice that there's some major countries missing, such as Russia and China, Brazil, India, the BRIC countries. And, well, they want to get more signatories to it, but also this was proposed by Russia and China to have this new treaty, and, well, they did want to make it a little bit more friendly to authoritarians. They also make a very legitimate point. Why should Europe be the boss of us? For a lot of countries who want to sign on to the treaty, they don't want to sign on to something which they had no part in creating. It makes sense. But one of the dangers of this is that for a lot of the countries around the world, they don't yet have a cybercrime treaty or law at all. And so what this comes out, while there are some abilities to vary it, many of them will just take it as is, and so we will care a lot about what it says and making sure when people are adopting it around the world, it comes to a good result. So the draft had many problems. For example, in the draft I was looking at earlier this year, there was Article 10. It was about the production, sale, and then you can see from there various countries' additions to it, like UK for United Kingdom and so on. So the distribution or facilitation of Iran had an addition they wanted to add. Technologies, software that would hiding the identity of its users. So they wanted to make it a crime to use something like Tor, a VPN. Also, Russia had an idea, which you can see Russia was in 4, and then Europe, UK, a bunch of other countries, US, were opposed, but making it a crime for distribution of information about vulnerabilities. Information about vulnerabilities is actually vital to be distributed in order to keep ourselves more secure. And I want to turn to one article in particular which is relevant to this audience. I call it the cryptocurrency provision. It's actually anti-money laundering provision, but it was adding cryptocurrencies to it. And you can see there in the second paragraph how broad it was. Any organization engaged in activities related to the circulation of digital financial assets and digital currencies. So related to is not just somebody who is a DeFi organization or an exchange. It is any ancillary business that's built on blockchain technologies could be related to. Extraordinarily broad. And this broad language, I think it could capture an open source project developing it. That's related to self-hosted wallet providers. That's related to, even if they are not in direct creation or distribution of a currency, sales of NFTs. So with that breadth, what else does it say? Well, it adds mass surveillance systems. So they wanted to require that countries would collect identity information for all users. If there was possible involvement in a cybercrime. Now that is an extraordinarily low standard. For example, in order to get a warrant in the United States, you need to show probable cause that there'll be evidence of a crime. Possible involvement, just tells a much, much lower standard, and not only of the suspect, who they thought was possibly involved, but also their associates and their family members. Now, it may be true that some people will hide money with their family members, but that doesn't mean their family members don't have rights and should be subjected to essentially warrantless surveillance at an incredibly low standard about somebody else being possibly involved. And there's a thing where any government who's a signatory could mark somebody for what they called enhanced scrutiny, and there was no standard by which they could be, well, this is someone who we think you ought to look at very closely. And of course, why is this a problem? Well, the UN is a very broad, most countries in the world are a part of it, actually being recognized by the United Nations. Some people view is what makes you a country. There are some people or entities who consider themselves countries who are not recognized, but it's most of them. And some of them have problematic human rights records. And we'll be able to use some of these powers in ways that we will not like. So for a blockchain network, how do you do it? Let's say you make an open source project, it uses some blockchain, and then they come to you and say, we need you to do enhanced scrutiny and give us the names of all of your users. And you're like, I just put this software out there and someone downloaded it and compiled it. I have no idea who they are. How could you do this? It was impossible for a lot of players in the system to be able to comply with this. So, good news. Article 93 is not in the September discussion draft. It just came out about 2 weeks ago. And so that is very good news. When we found out about this, I'd been working on this a bit with EFF. When I came out of Filecoin, Marta, who's the president of Filecoin Foundation, also on the Zcash Foundation board, and I wrote an op-ed in CoinDesk to raise the alarm. I went out to Vienna to talk to people about it for the 5th session. And had some very productive conversations. Industry was there. The International Chamber of Commerce, which is one of the largest organizations in the world representing industry, was there, and they were sympathetic to it. Talked to civil society, saw some of the issues there, though civil society had its work cut out for it for all the other human rights issues in this treaty. One of the things that sort of struck out at me that during the discussion and debate over this, Egypt sort of said the quiet part out loud. They said the word human rights appears too many times in this draft treaty. We need to get less of it. And also, geopolitical issues helped. As I mentioned, this is being proposed and advocated for by China and Russia. There are geopolitical issues between them and the EU and the United States. And so the EU and the United States wanted a skinny treaty, as they called it, which means not loading it down with a whole bunch of other things. And I think that helped them have a reason to say, get rid of some of this extraneous stuff, narrow it down, keep it to the core cybercrimes. So Article 10, they did not accept Iran's crazy proposal to ban Tor and VPNs, or the Russian attempt to remove discussion of vulnerabilities. And one of the things that's very, very important in it is previously it didn't have a lot of intent requirements. And the difference between someone doing something, especially in cybersecurity research, you are doing something that's very similar to an attacker, but your intent is to find the vulnerability, disclose it, and get it fixed, versus intent to steal some money. But if you don't consider intent when somebody's doing it, then it's up to prosecutorial discretion, and that can be abused, especially in countries that don't respect human rights. So there's still more to be done. There is currently Article 31, which is the new anti-money laundering provision, and it has some requirements to have any bank, financial, or commercial records to be made available to be seized. And like it says, the records are to be made available, so it's passive voice about who gets to have them and also who has to make them available. So that allows for a lot of a broad interpretation. They also have a specific provision saying, forget about your bank secrecy laws. There are some countries that try to provide extra protections for bank secrecy and use that as a way of getting some business and help their economies. That will be disallowed from this proposal. And then there are some other provisions in there, Articles 22 and 23, which will weaken dual criminality in the jurisdiction and allow for evidence. And we'll go for a little deeper dive on that one. So, dual criminality. So this is a concept that is around in international law. You may have heard of it in the context of extradition, whether someone can be extradited to face justice in one country from another country, and often there's a requirement for dual criminality that the offense has to be punishable in both states. And there are some wiggle rooms because people write their laws in different manners. So questions like, is it the same law? Is the definition too different or close enough? What about justifications? Like, could you have a self-defense justification in one jurisdiction, not the other? Excuses, like insanity is an excuse for criminal violations in some jurisdictions. But it is an important aspect of making sure that there's sort of fairness when you're dealing with different countries who have different ideas on what is criminal. But a lot of people who are proponents of law enforcement powers, want to give them more superpowers, don't like it. And in 2005, the EU experts on transnational criminal justice wrote a paper saying, here's what we got to do. We got to eliminate dual criminality, abolish as a whole. They have not been successful so far, but to give you that perspective. So how does it fit together? Well, Article 22 removes the general dual criminality requirement for the jurisdictions that had been in Budapest. And for the new one, jurisdiction over certain crimes against or by nationals wherever they are. Now, I should say this is weakening it. It's not eliminating entirely. There are some dual criminality provisions still in this treaty, and we're hopeful to get those expanded and clarified. But one of the other aspects of it is the evidence, the gathering of evidence, section Article 23. And so cybercrimes under the convention, okay, you can sort of understand why that would be in there, but then they go broader. Any crimes that use a computer. It's really hard to do anything these days without using a computer. Computers are being added to so many different things. If you're, engaging in your life, you're probably using a computer several times on a daily basis, unless you're living in a cabin in the woods. And then electronic evidence for any crime, even if that crime is not one that involves a computer. And for a lot of these transnational things, what are they looking for? They're looking for electronic records because that's where all the records are kept these days. So this is also extraordinarily broad. And then, as I said, jurisdiction over certain crimes that are in this treaty, well, it includes the anti-money laundering provisions. And so if somebody uses money involved in a crime, that could be one of the certain crimes where this broader jurisdiction. Now, again, I want to caveat, there was some good progress, as I was mentioning before. There's more human rights exclusions and limitations on how badly someone could try to implement this. But for a country that doesn't respect human rights, they may also ignore those provisions. So why does it matter? Well, there's a lot of different laws around the world where there's different points of view on what should be criminal. I call out a number of them here. Reproductive health care, that is the map we're showing there, is the various levels of standards and rules about reproductive health care around the world, and as you can see in the United States, around from state to state. Marijuana also varies widely across the world, whether it is completely unlawful, whether CBDs are allowed, or medical marijuana, or recreationalism allowed. LGBTQ materials are criminalized in some jurisdiction and perfectly lawful in others. And of course, for this crowd, privacy coins. There are places that have made laws that outlaw privacy coins, and there are a number of other jurisdictions that have talked about it or considered outlawing privacy coins. And so if you have jurisdiction without dual criminality, that means that a national of a country, when they go to somewhere which is a more permissive regime, if they try to find a place that fits more with their values, then they can still be potentially subject to the domestic law of the country that they left, even when they're in that more permissive country. And then the repressive country can try to seek electronic evidence from the more permissive country, and hopefully the more permissive country would realize that this was for something that was against their principles and say, no, we won't provide it, citing to human rights principles and resist it, but they might not. And having more protections in here is part of the job still to be done. And just to drill down on this a little bit further, in the United States, we had a situation where what was a constitutional right became a crime overnight after the Dobbs decision by the Supreme Court, which overturned Roe v. Wade, and there were a number of states that had trigger laws. So the moment that Roe v. Wade was overturned, those laws would go into effect, or maybe there was a 90-day delay and such, but they were designed to make it pretty much as quickly as possible to make something which had previously been lawful then become a crime. And financial records are potentially evidence for that crime. Many people use Visa and MasterCard. Visa and MasterCard are not great on privacy, but they generally don't have an itemized list, but they have metadata. And that metadata could be used in order to find evidence of a crime. Put up a couple examples here, like there are a number of online pharmacies that specialize in providing abortion pills, and if that's all that it sells and there's a charge at that place, then that could be metadata that tells a lot about what you're purchasing. Or if you're going to a health clinic and they have a variety of charges, and the charges that you have is exactly the same as the charge they might have for providing an abortion, well, that is metadata that can tell a lot about the content. And in the US, there are some financial privacy laws, but they were written with a notion that it was protecting against misuse of corporate information, but there's a big old law enforcement exception because they were based on the notion that law enforcement was always going to do the right thing, which I doubt, but nevertheless, they don't have a dual criminality requirement built into the Graham-Leach-Bliley. And what this means is if somebody seeks that information, they're not required to give you notice or the opportunity to oppose, to say, well, I'm in a jurisdiction which is lawful or something like that. So why does it matter? This is already happening. Search histories have been used as evidence of intent. Private Facebook messages. We have an excerpt from a recent news article came out last week about someone who was charged and then convicted, sent 90 days in jail based on private Facebook messages that were discussing her pregnancy situation. And then financial records are used all the time as a method of trying to determine crimes. They will frequently go to intermediaries, service providers, try to get financial records to find out what people have been doing. And a while back, when right after Dobbs' decision came out, some journalists were asking financial services, what will you do if you get one of these? And they refused to say that they would resist or they would provide an opportunity for people to resist on their own. All right, so I want to end on a better note. There are some problems out there, but we can solve them. I am an optimist if we work hard, if we fight on all these fronts. So fight on the policy front. So spread the word, talk to your friends, tell them about how privacy is a fundamental right and how much we need to have it. And this must include respecting financial privacy. Law, we push for laws and treaties that respect fundamental rights without overbalancing the scales towards law enforcement. And build the technology that will provide the backstop to both law and policy so people can quickly and easily use tools that protect their privacy, enhance their anonymity, enhance their privacy, and thus make the world. I ended this with be the change you want to see, but also the theme here is the future is not yet written, and this applies equally here. We're going to write that future, and let's write that future with good policy, good laws, and great technology. Thank you. And I got 3 minutes in case there are any questions.
Okay. One question from the Hoover app. When choosing between privacy and convenience, we often forgo privacy. What can be a good approach to incentivize people to care more about their privacy?
Well, I think that if you give people, I look at it as a little bit different way. If you give people a choice between privacy and not privacy, and otherwise those choices are equal, they will pick privacy every time. The question is how much inconvenience they are willing to do in order to get their privacy. And I know some privacy advocates who go through a tremendous amount of inconvenience because that's very important to them. But to have the society that I think we all want to build, we want to have privacy for everyone. So we want to reduce that convenience gap, that usability, the technological user interfaces, make that so it is accessible easily to all. So all they have to do is, yes, I want some privacy, and it works. Then we will get to this bright future.
Okay, I've got a question, just in the minute and 50 that we've got left. How much weight do policymakers and legislators and the type of folks who draft these rules and guidelines and treaties and laws, how much weight do they lend to the opinions of individuals who reach out to them, who respond to consultations, who email them, message them, write to them, etc.?
Absolutely. So that is a very good question, because how can you get involved? Well, how much weight depends a lot on how much effort you put in. So if you schedule a meeting with your legislature and go there in office and sit down and talk to someone who will be with a staffer, but not, that is a lot of weight because you showed you cared a lot. And especially you need to be, hey, I am a member of your jurisdiction, your district, I am a voter, I care about this so much that I came down to your office. If you can't do that, and that's a big pain, then making a phone call and talking to someone live, that shows that you care a lot. Sending a letter with a stamp, that shows that you care a lot. And email, well, shows that you care a little bit, but they have become aware of all the campaigns people have to just click a button and send an email, and thus clicktivism is given less weight. Signing a petition, that's also very easy to do, less weight. So putting in the effort is what gives it that weight, to show that you care, show that it's important, so this is something that you want them to do as your representative, and it matters to your vote.
It's something that said that decisions are made by those who show up. Maybe we need to be aware that decisions can be influenced by those who show up in the person's office. Listen, thanks very much, Kurt.
Absolutely, thank you.
We'll be talking again on a panel in a little while.